Hi, and welcome to another edition of the Trustcast Show. And happy to have with us today Jeremy Dover. Welcome to the show, Jeremy.
Thanks for having me, Zane. Happy to be here today.
Jeremy left Chicago for South Florida, like many people did, built a personal injury firm from scratch during the pandemic, and has now won millions for accident victims while managing partner of one of the fastest growing firms in the country. Jeremy, you were working at someone else's firm, and then one day, and you and Victor just decided to go for it. What was the conversation, and were you scared jumping in like that?
I mean, honestly, it happened one day when I was actually looking to buy a rental property. I wanted to invest. I wanted to find another way to have another stream of income. And my now business partner, Victor, was like, why don't we just take that money and start a law firm? He basically like framed it in a way that we'd been doing everything that a law firm does, all the way from handing checks to clients to signing up to doing everything just for someone else at the time. Was it scary at first? I mean, yes. I mean, did we know the pandemic was coming in like 3 months? No. But one thing he always said to me, and that made me feel more comfortable, is if we'd already worked at one of the biggest firms in South Florida, we had a track record, we knew what we did. If this didn't go well, we could find another job paying the same or paying more in 2, 3, 4 weeks at most. So yes, it's a risk to go out there and do it yourself, but do we have the backup if we need to? Of course. And that's something that set in my mind that didn't make me feel as fearful as I did at the same time, because I didn't come from money. I didn't have any background in money. Me putting this money in was just all the money I basically had. We started with 25,000 each. That is it. That is the only money we threw in there. We took no loans, we took no debt. We just did it and started grinding.
Yeah, there's a saying as burn the ships. It had to do with the Spanish invasion of Britain, and they decided
Mhm.
we're completely committed. We're invading Britain. We're going to take over, and so they actually burned their ships when they invaded, so that there was no looking back. So it
Their way to
sounds
retreat.
like you you burned your ships. I don't know how successful that was for Spain, but that's the story.
Probably a little different.
Yeah, but it sounds like you guys are doing great.
Yeah.
So
It's been a journey. Let's go with that.
you started your career as a guardian ad litem, a voice for kids with no one fighting for them. How did that shape the way you fight for accident victims today?
I mean, I started in the public space, like you said, in the garden ad litem. Basically, what that is if people don't know, when a kid gets placed in the system for abuse, abandonment, or neglect, there is the state, there is the parents, and then there's a third party that's a volunteer called a guardian ad litem in the state of Florida. They are there basically to represent the best interests of the child. It may not be what the child wants, but it is the best interest of the child based on their outside view. And we were their attorney. Now, from that, basically, our goal was to represent what would be the best interest of a child. So, finding the best outcome for someone. Now, when you look at the personal injury space, a lot of times you have to weigh a case for potential risks and potential outcomes, including the risk to the client. Now, with that being said, there's a lot of times you have to look, is a settlement the right solution for a client here, or is it the risk to go all the way to a 6-person panel and roll the dice and see how that comes out? And a lot of times clients, they don't like the number in front of them. They don't do this every day. They don't see the numbers we see. They have a skewed bias towards their case, which is understandable, but they don't have the same outlook of their case of seeing the negatives that the other side may be positioning. Now, our job is to represent to them and say, hey, we represent that this may be the best solution for you. There's a risk tomorrow. If you go forward with this, they have served a proposal for settlement. They can tax their attorney's fees against you if they do win. Yes, this number may not be what you want to do or what you believe is fully owed, but it's a settlement. A settlement is meant to be a number you feel comfortable with. It's not your best day in court. It's not the other side's best day in court. And someone told me that about mediation actually once, saying I was in with a mediator, and he likes to explain to them saying, remember, if this was your best day, we wouldn't be here. If this was their best day, it would be a 0 and you wouldn't be here either. No one's going to get their best day here. If you guys come to a settlement, it's an agreement in between. And sometimes that's the best path for someone. And you've got to make them realize that. Sometimes it is the issue that you've got to push forward and go all the way to trial and push it through because that is their best interest. And our goal is to support the best interest of the client. Whether or not that is exactly what they want, we have to give them our best counsel to tell them what we believe their best interest is.
So, if an accident just happened, someone rear-ended me or got hit on the freeway, what do I do in the first 24 hours?
I mean, the first thing you do, like on the accident scene, is first of all, make sure you're okay. I tell people that all the time. Like, make sure you're okay. There's adrenaline running through you. There's a lot of things going on. You want to make sure you're safe. And then you want to call the police. A lot of people avoid that aspect because they're scared of the police. They don't think the accident was big enough. But at the end of the day, if you're talking to an insurance company, they want to see that this accident happened and say he said, she said, if there's no police report. And the police report will document what they see on site, the damages of the vehicles, what they assess based on their experience. And then while it's not admissible, it helps to potentially alleviate the stresses of a case early on that you can maybe resolve it before having to waste a lot more time on an insurance company side or your side to basically put in efforts that the police report would help them feel more comfortable with, if that makes sense. From that point, you want to make sure that you get checked out as soon as possible. Now, the state of Florida has a thing called personal injury protection. Now, in the state of Florida, you have to go within 14 days of an accident to see a qualified professional to unlock $10,000 of medical benefits for yourself under your own policy because we are a no-fault state. So no matter whether you're at fault, they're at fault, the first $10,000 of insurance comes from your own insurance. And you have 14 days to unlock that. You wait past 14 days, you actually get penalized. So they will have the ability on the liability side to offset $10,000 of money that they owe, even though you got nothing out of it, if you fail to seek treatment within 14 days.
So, the other driver's insurance company starts calling me. Is it safe to talk to the other insurance company?
I say it's never safe to talk to any insurance company. I know that that sounds weird, your insurance company included, because anything you can say can honestly be used against you. Now, this isn't criminal. This is not that type of matter. But what I'm saying is an insurance company is still a business. Yes, they do insure you, but their job is also to make money. They are not always there to make sure that they just pay out every single dollar that you ask for. So they will limit their risk at the same time, even if it is your own insurance company. So anything you say, they can utilize as those statements to potentially limit their risk. And on the other side, they will use it to disclaim liability if they need to. So I would recommend speaking to your attorney and redirecting all communications directly to your attorney because this is what we do every single day. We know what points to hit, what things to avoid, and how to address them in a way that protects our clients.
So, if I get out of an accident and I'm feeling fine, I don't feel anything going on, do I still need to go to the doctor, or can I wait to just see if something gets worse or something happens?
I mean, I still recommend always seeing someone. That's the good part about, like I said, the state of Florida. You have $10,000 of medicals to use no matter what. Um, in that light, the same thing, like I said, adrenaline runs through you during an accident, even up to a day. You may not feel pain. You may not feel anything for 2, 3, 4 days later, but in that time, you are injured. So the sooner you seek the treatment and seek the attention you need for those injuries, which could be very detrimental to you if you keep going on without having treatment, then it can hurt you more. So I say the sooner you can get into a doctor, the better. I will honestly say I avoid clients going directly to a hospital unless they really feel they need it, just because the bills in the hospital are astronomical. And you don't know what type of coverage exists on the other side, if coverage exists, because the state of Florida is not a mandatory bodily injury coverage state. So you could be hit.
What is it? What does that mean? Mandatory bodily injury state.
You could be hit by someone, and they don't have to have any coverage for your injuries in the state of Florida. They can damage you. The only mandatory coverages here are $10,000 for yourself and $10,000 for property of someone else that you damage. That is it. So if you obtain these medical treatment, you go to a hospital, you can exceed that $10,000 with an hour of being in there. You get 2 CAT scan, be in ER, you get a $20,000 bill, and there's no coverage on the other side. You now owe $10,000 just for trying to check yourself out.
So, So let's talk about that a little bit because that's always an interesting thing. So you're in an accident, and on the other side, um, for whatever reason, that person doesn't have insurance. So usually that means they're broke, doesn't it? I mean, can you have somebody who has other assets that has insurance, and then is it worth going after those other assets? So let's say you're actually really injured in this accident, and then the other side doesn't have insurance, but they do have assets. Your life is altered maybe for 6 months, maybe for a year, maybe permanently. Really depends
Yeah.
on the situation. So, what do you do in that kind of, how would you advise a client in that kind of situation? Just the discovery to find out, do they have assets and can I get to them?
So you want to leave no stone unturned. I mean, w- there's a difference between not having coverage at all and having no policy, or having a policy without bodily injury coverage. And the reason I say that is, if you have a policy without bodily injury coverage, you still have an insurance company I can talk to. I can ask them for information regarding you. I can ask them to speak to you and say, hey, please fill out this financial affidavit so I can see what type of asset someone has. Otherwise, you have to investigate it yourself. And that's a harder stone to turn, because you may not be able to find it in the traditional methods, because a lot of people will conceal their assets or do different things. But traditionally, like you said, most people who do not have any coverage whatsoever usually do not have assets. And the other caveat you have is, like I said, when we're in the state of Florida, is the homestead state. So what that means is, any state with a homestead state means if you own your home, and that is where you claim homestead, where you live, where you get your tax exemption for homestead, you cannot take someone's home, even if you have a judgment against them. That's the only asset they own. You can take nothing of that. If they have two rental properties, all these other things, you can touch those. You just can't touch their homestead. And it was made that way to basically protect that no one takes the roof over your head, which is, we understand the logic behind it, but at the same time, if you hurt someone else, in our setting, it's a problem. But in other settings, like you owe a debt or you fail to pay credit cards or any of this, they can't take your home, which makes sense.
So really, in that particular scenario, you'd have very few options. I mean, you can't. I mean, could you garnish somebody's wages, or I'm just thinking of worst case scenario because you must have these happen. I lived in Florida, and
Yeah.
I got in an accident once. It was a drunk driver. I actually remember pulling off the side of the road. It was late, and she followed my car off the other side of the road and hit me head on. And she had no insurance. She was obviously drunk out of her mind, but
Yeah.
um, there was, and I didn't have any recourse. I don't imagine that's really changed.
There really isn't. I mean, you can try to garnish someone's wages, but the cost of doing so and going through, because a court can award a judgment, but a court can't make someone pay it.
Right.
Now, you can go through avenues of trying to garnish wages, but the cost of even doing it may be the preclusion that you have to even be able to get there. Paying an attorney to deal with someone trying to garnish someone's wages and go through that whole process is going to be someone you're going to have to pay hourly, because most attorneys who work in personal injury are contingency. If we go to garnish someone's wage, we're not going to get paid for that. There's nothing that's going to come
Mhm.
from that. So you're going to have to find an attorney who's willing to take an hourly rate, and you're going to have to pay that attorney. And is it worth paying that attorney for getting $200 a month, $100 a month, where you just paid that attorney 5 grand?
Yep.
It's going to take you 5 years just to recoup the money you just gave that handed to that attorney over.
So a lot of times the other opposing insurance will come up with an offer right away. I mean, they want you to, let's just settle this thing up. Here's
Sign the
and you
check.
look at it and here's the check. We'll settle this up. We can get you out a check. This week we can get it out right away, and then you put this whole thing behind you. Should I do that? I mean, is there cases where I should do that?
Honestly, I've really not seen many scenarios where you should do that. I have seen a couple. Let's say a death occurred and they're just willing to issue the entire policy, and they're not questioning it. They're done. This is all the money they have. There's no more. The reason I say to still go to an attorney is to try to search if there is more money. But at the same time, like, I've taken cases like that where we've gone and we'll say, hey, let us look to see if there's anything else. If there's nothing else, I'm not going to take an attorney fee from that. You would have obtained that money without me. It's fine. Those are the type of scenarios I would say that if they give you everything and you're sure that there's nothing else, because once you sign that, you're releasing the party.
Hmm.
Meaning if there were more money, you can't get it now. So that's the same thing that happens when they try to send you a $2,000 check or a $3,000 check right after you got in the accident. And the reason they're doing that is, like I said, they're minimizing their risk as an insurance. There is more money there. Most of those scenarios, they're just trying to get you to sign so you cannot go treat and get all your injuries taken care of. And they want to take an advantage of someone who just needs, hey, here's a check real quick. And you don't realize what you're actually owed or what would make you whole. Because the big thing people forget in personal injury is it's not meant to penalize someone. We're not trying to hurt the person who caused the accident. We're not trying to harm anyone. It's meant to say that you were injured. Now you've lost things. You have lost pain and suffering. You've lost medical bills. You've lost time. How do we put you back in the same place you were before that accident and make you whole again? That is the whole point of the civil system.
So, can you ever exceed the limits of the policy in a claim?
You can. Now, Florida substantially changed that framework with their House Bill 837 back in 2023, where it's considered bad faith. It used to be under third party, which is when someone else you're going after, or first party if you're going after your own insurance under uninsured motorist or underinsured motorist. Now, when they changed the House bill, they made it that there's certain parameters you got to get, certain procedures that I'm not going to get crazy technical about it. But piece by piece, you have to hit these key points to demonstrate that they could have resolved it within the policy limits and should have done so in good faith and failed to do so. And you gave them every reasonable opportunity to do so when you hit all the time frames that the law requires and all the requests that the law requires to give them notice that they have this option and they still have not done so. In that scenario, you can basically get a judgment in excess. Say it's $1 million and there was only 100,000. Then you have to go through a new trial. You go through a
Mhm.
complete separate bad faith trial to prove that they had all these options, they failed to do so, and they acted in bad faith. Now, once you do that, if you're able to prove that in the separate trial, then they are awarded all of those extra fees, and they can
So
be awarded to
let's
any
talk
number.
about bad faith because I've heard this many times before, and I'm not sure I completely understand the concept of bad faith. I mean, conceptually, I understand that the insurance company's trying to screw somebody over, and they're not being honest and they're not maintaining their deal. But can you maybe put a finer point on that than the generalization?
Yes, the simplest way I would kind of describe it is you have a case that demonstrates there is clear liability, there is clear damages that are in excess of how much money they have as total maximum. There really is no question as to why they have not resolved it right now at this moment, and they have all the information at their disposal to resolve this. They're delaying it unnecessarily. They're not reviewing it properly. They're not doing something that they should be doing in good faith to resolve this claim within their policy limits. And you've given them the opportunity to do so. You've asked for that 100,000. You're like, hey, this person can no longer walk. They are now a quadriplegic because of this accident. They were rear-ended. It's clear that the moment happened right afterwards. Here's all the evidence. Here's everything. Please tender your policy limits of $100,000 within 60 days. 60 days later, they don't even answer. They don't respond. They don't do anything. That is not acting in what's considered good faith. Now, at that point is where you can basically go forward and keep proceeding saying, I've got to represent the best of my, you're not resolving this in what should be a very easy case and very easily resolved. You didn't do so. Now I've got to push forward and do what I have to do and
So
represent their interests.
have you had one of these cases that went that direction?
I've never gone to a full bad faith trial, but I have had cases resolve in excess of the policy limits. Both in terms of individual contribution, meaning the person had money themselves that they could contribute, and from the carrier offering a little bit of excess, knowing that there was potential exposure for that.
So what is the justification for, when you get, I don't know, maybe you don't ever get into that conversation, but maybe I'm asking you to crawl inside their head, but what possible justification could an insurance company have for doing something in bad faith?
Honestly, I think personally, if I had to guess, it's more laziness than it is anything else. And to act in good dealing is to act in good faith and act appropriately, quickly, and efficiently. And to fail to do something efficiently is bad faith because you have a code of ethics that goes to adjusters, and failing to abide by that code of ethics, you're acting in bad faith. Now, a lot of them, don't get me wrong, a lot of them have a lot on their plates and things like that, but you're going to take up that role where you are holding the financial key to someone's life on how they go forward and how they pay their medical bills, pay their debts, and move forward after an accident. You've got to take that seriously in the light that you know that they're looking for this, they're looking for resolution, and you got to be the one who holds that lock and key. If you're going to do that, don't take it lightly and don't take on more than you can handle and know what your limits are. But some people think that they are able to take on more than they can and get caught in drowning over their head. And that's the problem that happens in today's day and age.
So, what's the difference between a case that settles and one that goes to trial? I mean, ultimately, it's not always the client who decides. You have to also, decide with them. So how do you negotiate that out? Client wants to go to trial, but you feel like you're not going to gain anything. In fact, you may lose something. You're putting everything at risk going to trial. How do you have that conversation?
Ultimately, it is the client's final decision. If they want to make that decision, even after all of our recommendation, but our job is to counsel them with all the facts. I tell them, hey, based on my experience, I believe the offer that's on the table brings you finality, helps cover everything, and is a reasonable offer at this time. If you go forward, here are the risks that stand. Here are the costs that potentially go into trial, because trial can range any from 20 grand to 200,000, depending on what type of experts you need to call, who you need to have appear, what other softwares you utilize for trial, depending on who you are as an attorney and what type of softwares you like to use for your trial preparation. How will you go into that can cost hundreds of thousands of dollars. That's costs that take off if, let's say, you go to the courthouse steps and settle it later. They may not be giving you all those costs back, and you are actually losing some money. So I like to tell people there's risks here because there's only so much here. There's only so much money total. If you exceed that, the money's not coming from somewhere else. So you got to know if you've got an offer on the table for 70,000 and the policy limit's 100, going all the way to trial may result in you walking away with less at 100 than you would at 70 right now. And I can lay that out for them in many different ways, and a lot of clients do understand it. A lot of clients, it goes right over their head, and they will be like, I want to test my limit and go to trial. And I'll push
But
forward
a lot of
because that's
times,
what they're directing me to do. But it's a
so a lot
mediator
of
told me
times,
once. Sorry,
yeah, go ahead. Sorry.
a mediator told me once.
No,
He's sitting there. We're talking to a client. And he's like, "Hey, he's like, this is the offer that's sitting here today. The way that you got to look at it is, I just threw that amount of money on your kitchen table. It's sitting right there. You can take it, or you can take that money and you can go down to the Hard Rock Casino, throw it on black, and you get one roll. That is trial. You get one roll on that, guessing black or red, and you will see what comes out. Now, those are your two options. You either take the finite money and take completion, take security, comfort, etc., resolving this, or you roll the dice, basically, or the ball, rather, and see how it comes out. Those are the two options, and sometimes people like the comfort over the risk.
Mhm. So, how long does it take? How long have you found that your these personal injury cases take from start to finish? Generally, I mean, I know that's pretty broad spectrum.
I would say the pre-suit side for most cases usually ranges anywhere from 4 to 10 to 12 months, because a lot of times we've got to know what's wrong with you. So you've got to go see all the doctors. You've got to go through your whole treatment before we can finalize a case, because we don't necessarily know what's wrong with you. We don't know the extent of treatment you need. We don't know the extent of your damages. So for us to ask for a number before that's done, we're not doing our due diligence as attorneys, and we're not counseling you in the right way. So you go through that whole process. We go through the negotiations. Let's say it stalls. Then we file a lawsuit. The courts are now, at least in the state of Florida, pushing cases to be resolved within 18 months. Is that happening? Some yes, some no. It just makes cases be expedited. I believe a lot of cases can be resolved. Smaller cases can be resolved within the first 3 to 7 months of litigation. Larger cases will push all their way to the first year to year and a half, like I said, to even 2 years. Those seem to be kind of the average higher end on cases that go all the way to mediation or trial would be 10 to 12 months, all the way through probably 18 months. Quicker cases where
So
we speak to an attorney that's now on the file because an attorney may not have been on the file during the pre-suit phase, and their experience talking to their adjuster says, "Hey, I see some problems with this case."
So what are the most common tactics insurance adjusters use to lowball accident victims?
I mean, they do when they lowball victims. I think a lot of times there's something I like to call litigation fatigue. Now, that's a tactic used by insurance companies where they want to draw out a case in litigation or draw out a case all the way through resolution because they're trying to people get tired of being in a fight. They get exhausted mentally, physically, stressing. They want to accept a lower offer just to be done with it. And they think that the longer they draw it out, that'll be the problems that they run into, and they'll accept a lower offer. So litigation fatigue is one of their huge tactics. A lot of times they'll try to scare clients with, like I said, a proposal for settlement, which in Florida is under 768.79. And if you do not accept that written offer in litigation within 30 days, there's a risk now. If you recover less than 75% of that offer at the end, they can tax you their attorney's fees from that point forward. So now the client has a financial risk. So they'll use tasks like that. They'll use tasks of fraud on the court if they find that you were saying the wrong statements, or a lot of times it's not truly fraud on the court. You just mix things up, and they use it to kind of scare clients and say, "Hey, I filed this motion. Your client said they had no accidents here. They had no history, but then they said they had this." It's not actually fraud on the court, but do they scare clients by saying fraud? Yes, a lot of times there's that. And then a lot of times they'll investigate, or they'll want to interview everyone in the client's history, and the client doesn't want their lives uprooted, and they don't want their family interviewed. So they'll rather resolve it rather than push forward.
Right. So go back to that one thing I kind of was interested in that about them if they give you a written offer and you turn it down. Let me understand exactly how
So
that you have a certain liability under. How does that
yes.
work?
So that's a statute directly in Florida. It's 768.79. It's the proposal for settlement statute. They wrote this statute to kind of help cases become full resolution. So when you're dealing in a damages case, a money case that's asking for money damages, they can send an offer to you. Either side can. If I'm the plaintiff and I send an offer for 100,000, if I recover and they don't accept it, defense does not accept it within 30 days, and I recover 126,000, at least 25% more in my final, I can tax my attorney's fees against the other side. Now, vice versa, they send me an offer for 100,000. I'm the plaintiff. I don't answer. I don't want to. I either have to answer and deny, accept, or just not answer, and it's a denial outright in 30 days. I don't. I deny it in 30 days. At that point, if they go forward all the way to trial, and I recover less than 75,000, which would be 75% of that offer, they now can file a motion to tax their own attorney's fees and costs against me. And the reason that is the courts are saying they gave you the option to get more money than you got in the long run. Yet you wasted the court's time, went through, you wasted juries, you wasted all the resources of the court, and ended up with even less money than they were trying to get done with this case forever, and wasted their time. So now they should get their money back because they tried to resolve it with you for less. That is kind of the logic behind it all. Does it move cases? Yes. It's a risk of people, and people have fears of risk. So as people are risk averse, they will sometimes make their answer and make their resolution based solely on that. But it helps to resolve cases in full because people want to see it in writing, and they want to know that saying no actually has repercussions.
So on the flip side, if the insurance company makes kind of a lowball written offer, and you're not even through with your whatever medical treatment that you have, they're putting themselves up for a potential bigger loss, or that could
No,
be
they
even
would be
seen as
fine
bad
though.
faith, couldn't
It
it?
has to come from
They,
your side, and it has to be during litigation. So
oh,
if
okay,
they offer me 100,000 and I recover 125, it does nothing. I have to be the one making the offer if I'm the plaintiff, and I have to recover more than 25% above my offer. Now, on their
okay,
side, the only thing they can benefit is if we recover less than 75% of their offer. So it's a one-way street with the actual proposal for settlement.
Oh, so the insurance companies have a little bit of a wedge there.
Yeah. I mean, we send it on
Yeah,
our side and we can kind of get our attorney's fees too, but then again, we're still capped at policy limits no matter what.
right. Um, so someone says your injuries are just soft tissue; they're not really that serious. We're going to pay you an inconvenience fee. What do you say to that?
I mean, back in the day, soft tissue injuries were, you wouldn't see the verdicts in the high figures, but I've seen soft tissue verdicts in the seven figures. No broken bones, no permanent damage of turning, like, let's say you can't walk anymore, any curvatures, things like that. Soft tissue injuries hitting the seven figures. It's not common. Do not get me wrong. It's not an everyday thing, but you can get there. So to say that soft tissue injuries are not permanent in nature, I don't 100% agree with that. And there's a lot of doctors out there who I have used as experts who would not agree that soft tissue injuries are not permanent in nature either.
Yeah, as someone who's been an athlete throughout my life, I can testify soft tissue injuries can be permanent. So
Yeah.
if the insurance company says I was at fault or partially at fault, how does that affect what's going on, what the end result is?
So that'll go back to, and well, at least in the state of Florida, we changed that framework in the same 2023 House Bill 837, where it changed us to, if you are a plaintiff and you are seeking injuries and you are deemed more than 50% at fault for the accident, you can recover nothing. Previously, you used to be able, if you were 80% at fault and the jury found $100,000 was the damages, you would get 20% of that. They would cut off 80 and then you would get the remaining 20 and reduce the 100 down to 20K. That's the same way it works if you're less than 50K. But now if you're over 50 or 50%, sorry. Now if you're over 50% here, you get nothing. But if you're 40% and they're 60 and you get a jury verdict for 100, it will reduce it down to 40. You will get the recovery based on the percentage down to 60, I apologize. The percentage at fault that the liable party, the person who caused it, how much damage times their liability.
Hmm. So if I have pain and suffering, does that fall outside of the general liability claims of or liability limits of the insured?
Nope, that falls in the same liability limits. It's all inclusive. The bodily injury coverage that exists is for medical damages, loss of time, loss of consortium, and any type of pain and suffering that will be included. But in the state of Florida, and for at least a car accident case, you must find that your injuries were permanent in nature to recover pain and suffering. So if your injuries are not deemed permanent and you get back to you're back and you're fixed and you're perfect, they don't allow recovery for pain and suffering in the state of Florida.
Hmm. So, so if I already signed something the insurance company sent me, is my case done?
It depends what you sign, what you did with the check, what the circumstances were. There are times that you may be SOL, I'm gonna say for lack of better terms, and there are times that we may be able to get around it depending on how the circumstances came about that actually occurred and whether or not you cashed the check, whether or not what you signed is, we'd have to review the actual document and things going forward. But there have been times we've been able to get around that early signature result and get a client a full result from their actual coverage that was outside of that.
So your firm, Deme Demesmin, Demesmin and Dover,
So
is
think
that
of
right?
everyone misses the second M for him, and I don't know why. So Demesmin.
Demesmin,
Yep.
Demesmin, Desme Demesmin and
If
Dover.
you saw the SEO background Google searches that we get, it is hilarious the amount of names that I've seen him spelled. Although mine's always correct.
Yeah. So, what's the plans for your firm over the next, I don't know, 3 years, 5 years?
I mean, we've done a lot of different things since we've opened this firm, and that's kind of been the interesting part of it all. Since we opened in 2020, like we said, we outgrew our office by mid-year, and we moved into a 10,000 square foot office by October. We grew to a staff of about 75 right now. We opened up Tampa. We have a Tampa office. We opened up, I'm also licensed in Illinois, so we have a Chicago office that we recently opened. We moved that office to a full service office from a more of a WeWork setup probably the past year, and moved into their full office about 2 months ago. So we keep kind of growing in that way. And then people say, oh, you guys are growing so fast. And I agree with it, but you have to grow proportionally fast. You can grow quickly and it's not a problem, but you have to make sure it basically matches the work, the clientele, the staff, and everything needed to keep growing, because hire slow and fire fast is something that we learned along the way. You need to hire based upon true needs with a slight expectancy of what's coming in the future. You can't just base it on, we projected this and then we're just going to hire 5 more people, but this line that you have starts stagnating. Now, from that, I would say that I'm more of a serial entrepreneur than I am a lawyer nowadays. Because from the law firm, we've opened about 6 restaurants. We've done an animal shelter, a 501c3. We've done a sports agency where we represent a lot of bare knuckle fighters, some NFL players, and things in a separate agency that we have upstairs. We still utilize our legal background for that, of course. I'm also an NFL licensed agent. So we do a lot of different things that we allow the firm to kind of be the focal point and the foundation of it all. But it helps us expand in many other ways where we can touch the community in different ways and touch other people to help them in different ways outside of our traditional law space. And like you said, we started in personal injury, but we do personal injury. We have a workers' comp department now, homeowners first party property insurance department. We have a department for criminal defense. We have a department for probate, trusts, and wills. We're kind of full service at this point, besides maybe family and immigration are probably the only 2 things we don't touch. But who knows where that'll be in 3, 5 years? Probably. We'll see. If there's a need,
Yeah.
we'll get there.
So, how do you guys? I would think that that would be difficult, time wise, to manage all these different things going on. You must have some key people other than you and Victor. You must
Yeah.
have some key people there that you kind of are, willing to, or trust in a big way.
Yep. I mean, our first attorney we ever hired is still with us today. We hired him back in 2020. He's now become a junior partner in the firm. Um, from that, we've had other people that we hired within that first 6 months in our original office, which was about 2,000 square feet, maybe 1,800. And at least half of those people are still with us today. They're not in the same roles they were in. They came in as legal assistants. They were doing paperwork. Now one of them is the executive assistant to my business partner, who also handles oversight on the marketing side. Another one handles the director of business development. Everyone who is, we hire people based on personality. All of those people really didn't, at least 80% of them never worked in an office setting before working in our office. Now, anything can be taught if you have the right mindset to want to learn and to want to grow with something. That's where people have a foundational problem, is they hire based on a resume and a written resume with their background, but you got to hire on personality. I've let people go. We've let people go who were some of the best producers that you could have in a business, but their people skills internally in the office were lacking, where the culture was suffering because of this individual person or these people. I'd rather have a happy environment where people are producing and happy that they're coming to work every day, where they spend more time than they do at home, than a miserable place that just churns out money. It doesn't work for us. It doesn't work for our goals. Our goals are to have a place where we create a culture and we influence lives that make changes in their life and help them for better in the long term. And that's kind of like what drives us more than just money's great. But if you put a good product out there, money will come. And the same thing that you look at Amazon, you look at Google, you look at any of those, Elon Musk didn't get to where he is without a team. There's a team behind him that is running everything, that is doing everything, and that helped build that to where it is. Do not get me wrong, he's brilliant in what he's done, but there is a team there that has done a lot of that too. And that's what we have behind us. It takes a village. We didn't get here by ourselves, and we're not going to keep growing by ourselves. For us to be able to do what we need to do, we need to have a strong team behind us, and we've helped build those teams, and creating more leaders is what you need to do.
Okay, that was a great. Let's wind it up right there because I think that was a good ending. Thank you, Jeremy. I think you
Of
were
course.
a really good guest.
No, thank you for having me.